Greetings everyone. I Khushbu Chawla from Team Legal Vidya welcomes you all to the 15th class of 9-week certificate course on advanced legal drafting by Legal Vidya. Now, I would like to welcome our honorable speaker of this course, Ms. Shivani Gupta, to take the session forward. Welcome, ma'am.
Good evening, Legal Vidya. Good evening, participants present over here. So, new day, new draft we will share. And today we will share 3 to 4 drafts under the CPC. We will continue with the same. Wait for a second. I'm just sharing a screen. And the draft for the today's class I have already shared in the group. I think you might receive those files in the group, no? Wait for a second, just. So, as you all know, that today's topic is all about the written statements. We will discuss in for 1 to 2 minutes. I will like to just to give you some insights that what the written statement is, how the written statement is being prepared. Is screen is visible or not?
Yes, ma'am, the screen
Oh,
is visible.
thank you, thank you. Okay, so without further any delay, we will starting just with the written statement. In the yesterday's session, we have discussed about what the plaintiff. Now the thing WS, it means that the stands for the written statement under the CPC. Whatever the first foremost, in a very easy way, you can understand written statement is just like a legal document that is being filed by the defendant, and the document that is being filed by the defendant for the kind of a response that is being made regarding any petition, any complaint, or plaintiff's suit or something. So there are certain defenses denies, there are certain defenses counterclaims, there are certain defenses statements or something that are being on the defendant side, so that are being mentioned in the written statement itself. So either the defendant will admit all the allegations that are being put forward in the plaint as per the plaintiff, or he will deny. So these are all the things that are being mentioned under the written statement. Particularly, there are certain components also. As per the components we have discussed of the plaint, the same are with the written statement, including the title, introduction, background, response to the allegation. Why I am going so fast today? Because there is no such relevancy of going through the same, because these PDFs I have already shared to you. You can study, read them by yourself. We will discuss the draft, because drafting section is more important than studying the law. That's why there are certain response to the allegations, affirmative defenses, witnesses, evidences, counterclaims, and so on. And some kind of a relief sort legal citations are there, verification, date signature, along with the annexer. So these are the kinds, these are the components of the written statement. I am just putting forward this. Now I will share the very first draft of the same. For the written statement, you just keep in mind one thing: whatever the suit, whatever the plaintiff being filed by, the application being filed or suit being instituted by the plaintiff in the court, then response to that, a legal document that is being filed by the deponent or the respondent in the response to the same is known as the written statement. In the written statement, the draft is as per same, or the format is as per same. Only there are certain affirmative defenses, counter claims, there are certain reliefs that are being mentioned in the written statement. So this is all about the written statement. Now I will share the another screen that talks about the drafts of the same. In the PDF class 15, that everything is mentioned. Wait for a second. I'm just sharing the screen. First appeal is also there. I have to discuss the first appeal also. Wait for a second. 114. Now I'm sharing the file number 15D. You can also open the screen in your mobile, or either you can just go through the screen what I'm sharing in the class. Does the screen is visible now? Okay, Ranvijay. Okay, Srishti. So yes, the whole class will discuss about this thing. This is the format of the written statement. You are already saying when you draft the written statement, you need not to mention the written statement format. You have to just start mentioning with the code name, that is the in the code of civil judge, district is this, and the suit number is this, and the year 2024 is this. Or and the above mentioned things, those are the written statements format. The written statement on the behalf of a defendant format is given below. No need to mention that. Now I will start discussing with this. Yes. So now what happened? So you have to just need not to mention these things. You have to mention in the court of which civil judge. Okay, the district is which district, suit number is what. Now we will mention X, who is the plaintiff, versus the Y, who is the defendant. As we all know, written statement is filed on the behalf of the defendant. So most respectfully show it. These are the facts, that is the primary objections that are being made. That is the suit is barred by the limitation, for example, article number or the section number of the Limitation Act, and liable to be dismissed on the short ground alone. So first of all, we have denied that the suit can't be maintained because there is a bar by the limitation, and that is applicable. Now, the next thing is court has no jurisdiction to entertain or try this suit because reason we will specify. Next is the suit has not been properly valued for the purpose of the court fee and the jurisdiction. That could also be the reason for the same, that the plaint must be rejected or the suit must be rejected, because on the very foremost reason, the defendant always try to just get rejected the suit no matter what, and with there is no absolutely no cause of action in favor of the plaintiff and against the defendant, so that the suit is liable to be rejected. Next is the suit is bad for non-joinder of the necessary parties, namely jo bhi necessary parties are there, then the suit is bad for non-joinders. We have to mention that thing also. Now misjoinder also, that is also bad for the misjoinder, so that thing also we have to mention particularly what are the aspects on which behalf the suit uh, uh, must be rejected, the plaint must be rejected. The plaintiff has alleged breach of the contract by the defendant, assuming though not admitting the defendant has committed only alleged breach. The remedy to the plaintiff is by the way of the suit for the specific performance and not sent for the specific performance, so the suit must be rejected. So there are particular reasons that must be mentioned as per your circumstance, as per your nature of the case, as per the nature of the plaint being filed. These are the specimens, the sample specimens. Now, on the behalf of a marriage, I have mentioned after the point number 16, it's on the behalf of the married also. On the behalf of the married, that without the prejudice to the preliminary objection, this is the sample language. And if you are wishing to prepare any of the WS, then you can use these vocab, these languages, these phrases for the same. For example, without the prejudice to the preliminary objections stated of the reply on the marriage, which is without the prejudice to one another, is as under. For example, the para number 1 of the plaint is correct and admitted. Para number 2 of the plaint are denied for want of the knowledge. Para number 3, a plaint are absolutely incorrect and denied. So these are the things that must be mentioned clearly. Now that the other things is that the para number 11 of the plaint is incorrect, or that must be denied. Number 21 not admitted at all, or para number 13 is also like not admitted at all. These are the things that you are asking the court, that you are saying the court that the allegations that are being put forward in the plaint must be rejected, and these are the grounds or the reasons. That's why you are asking for the court to reject the plaint. You have to mention those all points that on which behalf you are not accepting the allegations, or you are requesting the court to dismiss the suit or reject the plaint. Now, therefore, next important thing, that is what is the relief we are seeking from the court, that is the prayer. It is therefore respectfully prayed that honorable court may dismiss the suit. First of all, is this that dismiss the court. Next is that the award cost to the defendant or any of the just and equitable order. Now then, what would happen? You have to sign. The defendant will sign through the sign, and the place and the date, and the advocate signature must be there. Advocate sign. Verification must be there. Verification is just like that on the particular date or the time, the particular paras that are being preliminary objections, and the next paras are on the marriage due to the personal knowledge, and there are certain paragraphs that are being need to be true and the correct, and on the basis of legal advice is received and the believed to be true, and this must be foremost signed by the deponent or the defendant, as this is the sample format of the written statement that is being put forward to prepare any kind of a written statement for any of the suit. Yesterday, I have given you the task just to prepare a plant in the matrimonial dispute. It's an imaginary, hypothetical plaint you have to draft. How many have you draft? No one has shared to me till now. Please raise your hands. Okay, Anmol. Okay, Anmol has drafted. No one else, I think, have. Oh, okay, okay, Anmol. You have just raised your hand. Else, so today's task is about first task for today. You have to prepare the WS for the same. For the same plaint, you have to prepare the WS also. If you people are acquainted with the format of the WS, okay, Anmol. If you are acquainted with the format of the WS, shall we jump into the another format? Because today I have to explain you the four formats. Yes, Shrishti. Any problem? If anyone have any query, question regarding the same, please feel free to put in the chat box. Yes, I ask. Please, if there is any doubt, please ask. Or are you raising the hand because you have just prepared the plaint? If yes, then very good. Wait, let me share the another. Yes, there is another one query. Miss Joinder and Miss Joinder point, what is it about? But there are two things under the CPC. The whoever is asking the question, there are two things. First is the Miss Joinder and second is the non-joinder. In the CPC, it means that it particularly inclusion and the exclusion under the civil suit. The parties can be included or parties can be just excluded. Anamika. Madhukar, what is denied for the want of the knowledge? Denied means you are not accepting what is being mentioned as a fact in the plaint. You are saying that you are clearly rejecting the facts. That is being denial under the CPC pleading. Ranvijay, madam, I usually was unwell, will not attend the class, will try to take task. Okay, Ranvijay, no issues. Anmol, so the sole purpose of the WS is to reject all the points of the plaint? No, not at all. There is no such purpose, sole purpose of the WS to reject the plaint. The purpose of the WS is just to file what is on the behalf of the defense. The defendant is putting his points, defendant is putting forward his defense. If in his defense, all points, all the issues that are being raised under the plaint are non-negotiable, are being rejected or are not true to the knowledge, because the statements in the plaint can also be false statements or the allegations the defendant is not accepting, then Akash, what is cause of action? So how we identified on case? How do we identified on case? Okay, cause of action is just like when the dispute is raised. Okay, so how you have to identify it over any issue two parties are fighting? Then that is the cause of action. No? Yes. I asked Sayyad, madam, against the complaint in 138. First of all, this is not the manners to just mention the question against the complaint. You are asking about the criminal law here. Complaint is in the criminal law. And first, next is 138. This is not the way to mention. You are a law student or law belonging to the law fraternity. Just to put it, write it down like under section number this of which act. And you are talking here about which act, either BNS, BNSS, or any other law. Please clear the question. Do we need to reply by the written statement or the response to? Didn't get it. First of all, I ask, please put your questions correctly. For which section are you asking for? Which order are you asking for? And which law? So that is 138 of the Negotiable Instrument Act, na? And this is not cheek bounced nahi hota. It's not cheek bounced. It's a dishonor of the check. You can't use this like layman language when you are talking about the law. So it's a dishonoring of the check under the section number 138 negotiable instrument act. Look, in the earlier classes also I have cleared it so many times that negotiable instrument act hold the both the liabilities, either it's the civil liability or either it's the criminal liability. Section number 138 also dealing with the criminal liability. So in that situation, we do no need to file the written statement, because for the section number 138 Negotiable Instrument Act, please mention it correctly because other students are reading the same. It's section number 138 that is talking about the dishonoring of the check. Okay. Now, when we discuss about the section number 138 Negotiable Instrument Act and the criminal liability is there, or when the criminal liability is there, then the case will run as per the criminal trial. Any of the trial as per the BNSS laws, not as per that CPC. I think your doubt is clear now, Ayaz. And it's not cheekbones, it's dishonoring. Yes, we should move further to the another format. Yes. Anyone else have any question? Then please feel free to ask and just clear your doubts. Okay, okay. Next, I have to teach you this format too. In form of first appeal. Okay. Now this. This is all. This my screen is visible to you all. Uh, I hope
Yes, ma'am, the screen is visible.
Okay, okay, thank you. Yes, now, as per the schedule, if you see in the today's schedule, there are other points also that we have to discuss, because a written statement doesn't solely solve the purpose to study the WS or to study the CPC. So, along with that, we will discuss some unnecessary other provisions also, some necessary other formats also. So, in the today's session, we're gonna discuss the same. First of all, this is a application for setting aside. You can check in your schedule. It is the order 9 rule 13 application. So under the order number 9 rule number 13, we put forward the application for setting aside the ex parte decree. Now what would happen, and the application will be filed on the behalf of the defendant for setting aside any of the ex parte decree that is being given under the order number 9 rule number 13, and that is also read with the section number 151 of the CPC. Now what happened, sometimes first of all we will understand what the law is, what the concept is. There are two terms here, setting aside, next is the ex parte decree. For example, if the ex parte decree is being passed, then what would happen, ex parte decree is mostly passed in the absence of the defendant. If the in the absence of the defendant, it could be just like that the defendant can't be heard or he is not available there, then the court take the judgment decision and pass the decree. So now the defendant and the defendant now given the last opportunity that what are being the decision, the judgment being taken, and then the decree being passed, and for setting aside that decree, that for the ex parte decree, the application can be put forward in the court, and the application provisions are given under the order number 9 rule number 13, and that are particularly read with the section number 151 of the CPC. Here I will not discuss each and every BRAC provisions, but I will tell you here that what are the particular format for doing so, because in the schedule it's being asked to. Now what's the particular format, we will start it with, just like no need to mention this part, setting aside of ex parte decree under the rule number 9 or order 9 rule 13. You have to just mention in the court or court of civil judge, and that is whatever the central district, Sajari or Indore or Lucknow, whatever. Okay. Next, you have to mention the year also, and the suit civil suit number also, in the matter of the who is the plaintiff, who is the defendant. Here the Anthony Gonzalez is the plaintiff and the Robert is the defendant. Now we will mention subject matter, that is the application on the behalf of a defendant for setting aside ex parte decree, and that is being dated on particular this date under the rule number 9 order 13, that we will read with, as already told you, section number 151. Now most humbly show it, these are the phrases you must use particularly. These are the phrases. Okay, the captioned suit is pending before the honorable court and pending for hearing on the that particular date. First of all, we will mention it like this, and you have to start writing or draft this application in this way only. This application is being filed for setting aside the ex parte decree, that is being a decree passed on that date, and the account of non-appearance of the defendant. Look in the point number 2, I have already mentioned this thing on the non-appearance of the defendant when the suit was called for hearing. The defendant was not there, so decree was passed in the absence, and more of the opportunities were given. Now, in the third point, that that defendant mentioned that why he was unable to come to the court. Next is the defendant has already filed the complaint against the persons in the court, and they have annexed the copy of the same complaint. Now that the defendant was informed by the court staff about the ex parte decree that is being passed. Now the defendant directs the counsel to file the application for setting aside the same day the application was filed. This is point number 6. And now the defendant is diligently defending the case, and the past has never failed to appear before the court. So these are the certain points that are being mentioned. On the non-appearance of the defendant was not deliberate or intentional, but on account of aforesaid reasons, and aforesaid reasons were mentioned in the point number 6 also, or the point number 5 also, that is annexed with the complaint copy. Now the defendant will gravely prejudice prejudice if the order is not set aside. And now we will mention the prayer. What's the prayer is? Prayer is that what are you are looking for, the set aside the degree that is being passed on this date or pass any order. Now the applicant means the respondent will sign here and the advocate sign here with the date and the place. So this is a, and this will be accompanied by a affidavit, as same as the affidavit that we filed under the CPC also. This is a very interesting decree actually, and this is a very interesting case actually. And once in a week the defendant filed these kinds of a application, so you must start practicing upon that and start reciting those phrases. Yes, anyone have any query regarding the setting aside degree, ex parte degree application? These are the simple, straightforward applications that are being put forward just to communicate what you are looking, seeking for from the court, and what why you are in trouble. So that's the kind of a momentary remedies that you can seek from the court on the behalf of certain applications, but these works in the civil proceedings only, not in the criminal proceedings. If anyone have any query regarding the same, please let me know, else we will move further, because today 4 applications are being required to share with you all. Okay, Ranvijay. Yes, anyone else have any query, or did you get the thing? And after the session is over, please try to just go through the draft once again, so that you must be just like revision to you all. And please keep the drafts in the soft copy somewhere, just saved in a folder, because might be very helpful for your academics also, for your future endeavors, for your litigation experience and everything. I hope you understand. Now we will jump into the shall we jump into the another draft, or we have to be just on this draft only? Okay, Shrishti. Okay, I think 2 3 students are there to whom I am acquainted with, and I think they are acquainted with, they are just giving the thumbs up and everything. Yes, yes, please put your hand down. And advocate Sakshil, please put your hand down. Sakshil Pangarkar, please put your hand down. And else 24 participants are there, not even giving a thumbs up or raising their hands. I think I'm just acquainted with 2 3 students. Yes, Sony is also there. I'm acquainted with her also, because she asked so many questions. Anamika Sharma is there, who every time asks me. Akash is there. Yes, yes, yes. Nagendra is there. Yes, yes. Yes, I am acquainted with you 4 or 5 students, especially. Okay. Now we will jump into the another draft. I hope just you just ask me, clear your doubts. Okay, now the another draft. Another draft is regarding the civil appeal that is being filed under the section number 96. Section number 96, I think I have mentioned in the appeal also somewhere. Appeal. Okay, so appeal is just like a form of a first appeal. Very simple, a very delicate, very kind thing. Okay, now we will mention, we will study how the appeal is being filed, what is the draft, and what is the permit. Now, in the court of a district judge, whoever it is, and most important thing, yes, when you are learning the drafting, na, so it drafting includes, it doesn't include the word file settings, because in this word file, in this sorry PDF, the every arrangement is in the right alignment. So don't be confused about the facts. It must be in the middle alignment or in the right alignment. It can be vary. So no need to just rely upon these facts. You have to just go through whatever the matter or content is absolute. Or you must be confused like, okay, कि right alignment is there or left alignment is there. They are, वो सब बात की बात है. अभी we have to just learn about what's the draft is. Now in the court of a district judge, whatever the district judge, it is civil appeal number is this, and year of this. So this is the defendant or the appellant, or this is the plaintiff or the respondent. So defendant is also known as the appellant, and the plaintiff is also known as the respondent here, because it's an appeal case. Now just go with the thing that the plaintiff now converted to the respondent. Why? Because it's an appeal case. Now there are certain grounds for the appeal also. Now what are the particular grounds is that the above named appellant files the appeal under the section number 96. Under section number 96 only the first appeal are being filed under the CPC. So please always keep in mind for the same. Okay, now wait for a second. I have shared another video. Yes, screen is visible now. Yes, the screen is visible. Okay. Now, what would happen? Just because and it will be mentioned like the phrases we will use, but we above named appellant filed the appeal under the section number 96 CPC against the decree that is of date this, and the decree was passed by the additional civil judge. Ye ADDL is additional civil judge here. In the original suit means the plaint is there. Original plaint is there. number is this, and the appellant and the, oh sorry, plaintiff and the respondents is this, and set forwards the following grounds of appeal, which is valued at rupees this. So we have to mention the court value of the same, or suit value of the same. Now, the what are the things we can use, or what are the phrases? It's just like, because the plaintiff failed to prove his readiness and the willingness to have the sale deed executed within the time, the court below is contrary, is wrong. Next, because it has been fully established on the record it was the plaintiff who committed the breach and not the defendant, so the contrary is erroneous. Next, because no notice was served on the defendant by the plaintiff, the period of fix of this execution deed, the findings of the court below to the contrary is incorrect. Both the parties having entered into the evidence regarding the service of the notice under the section number 114. Now you can change it to the section Bharati Sakshi Sanhita BSA. And next is this, because it's an old draft being prepared as per the evidence law, old evidence law. Now, because the judgment of the court below is bad in law and the facts deserve to be set aside, so these are certain grounds from the point number 1 to point number 11. There are certain grounds. The rulings cited upon the court are not applicable. These are the grounds on which the appeal is being cancelled. You people just wait for a 1 second. I think someone is there just on ringing the bell. Just give me 1 second. Just stay in the class only. I'm getting you back in 1 second. Please just stay in for 1 second. I hope you understand. Just 1 sec. Yes. Are you there in the class? It was someone not just ringing the bell. Okay. Yes. So we were discussing about the form of the first appeal. Okay. Okay. Same missing. Okay. Okay. Got you. Got you. Okay. Now, this is what there are the points that are the point number 1 to 11 that we have discussed about what are the particular grounds that on which the appeal we can file. Okay. Now, the for example, the plaintiff has disentitled the claim specific performance of the court by claiming damages for breach. And for dear participants, just keep in mind one thing, that is for different aspects, for different case natures with different issues, the grounds can be different. I have just given you the sample idea, so you can use these samples or the phrases for the reference. Now is that the another thing, last in the last, it's just like you have to just mention it's prayed that the appeal is allowed with cost and the suit of the plaintiff can be dismissed with the cost, and though there you have to just sign, and the appellant will sign, and the appellant and along with the counsel both will sign the draft, sign the application. That is the form of the first appeal there. Now, anyone have any question regarding, I have discussed you three drafts. Anyone have any doubts or queries or questions? Please feel free to ask. At least make this session interactive as much as possible. No one have any question? It's brilliant that no one is having any doubt or something. But I'm just like, just make the session interactive as much as possible. Are you all acquainted with the drafts I'm sharing? Should I start asking you something? I have mentioned here one thing, that is the first appeal. No one is asking why we have mentioned this term first appeal. Why it's not the second appeal, third appeal, or only appeal? Who will answer this question? Okay, you tell me now. Anyone? Everyone will be blank now. I have mentioned the first appeal. Yes, anyone, please just put something in the box that what is the first appeal or the second appeal. Most important thing, madam, because the we can file appeals in the hierarchy of the court. Okay, Sony, because it's the appeal after the original decree. I didn't get you, Anmol. Actually, first appeal is a kind of a appeal that is being passed by the courts in the original jurisdiction, and moreover, the appeal can be challenged in the courts, in the higher courts as per the hierarchy. But that courts can't be the, even sometimes they are not the high courts. So that is also that's why we called it as the first appeal. Okay, I think you understand. Now comes the another another thing, another PDF I will share you all. Okay, now this is a very important PDF regarding the same, that is the humble application under the section number 114 of. Okay, you have to just prepare the draft for the review application also as per the schedule. Anamika, madam, there is a thing, whatever I can see, files and proceedings, it become really difficult to understand and often overwhelming as to what we will come after what, like when written statement is to come, and or when the argument has to happen. Can you please help in that? Okay, I will share, Anamika, I will share you with the I am already shared you with the civil proceedings steps also in the very first day, when we discuss about the CPC provisions. Then civil litigation, I have discuss the steps, that okay, when you file it's 18 steps, there are the civil suit being filed as per the CPC. So I will yes, yes, and so I will, if you need to, then I will discuss those again here also. Okay, just make your revision of the same. Wait for a second. Yes, it started with the presentation of the plaint. Then first of all, the presentation of the plaint, wait, I am just putting all these things in the chat box also, no? So you can just wait for a second, you can just read them. That the message is displaying to you all. Appeal, review, revision, execution of decree. It's appeal, review, revision, followed by execution of decree. Once you go into for the litigation, ma'am, when the petitioner became defendant and vice versa. Nagendra, is very simple. Na? When you go for the appeal, then what would happen? The defendant will become the petitioner, or then, but he will be called as appellant there. Then the plaintiff will be known as the deponent there. No, it's as simple as that. During the appeal, na, you just keep the concept in your mind also. And vice versa means what? Petitioner become defendant. Yes, petitioner become the defendant in the case of an appeal, na. Only thing that when it become vice versa. Now it's the last draft of the session, that is talking. We'll try to understand next time from this format only. Yes, Anamika, and no need to just learn these things. You have to just keep in mind that first of all, you will institute the suit, that will follow by the summon procedure and so on. Then after that, there will be appearance of party. Then ex party decrees there. If there is no party, there is dependent. What I'm saying, defendant or deponent is there. Then if there are certain interlocutory proceedings, interim relief is required, application will be put forward. Then there is a written statement by the defendant. Then is the production of the documents, examination of the parties, discovery, inspection if required is there, admission, framing of issues, then the arguments, and then the some arguments, then sorry, then the summoning of attending or attendance of the witnesses, hearing, then the examination of witnesses, cross examination, followed by argument, judgment, decree. And then if the person is not satisfied, then the appeal, review, revision petition are there, provisions are there, followed by the execution of it's not decree, it's decree. Typing error, please kindly consider. Wait, I'm mentioning this also. Typing error is there. Okay, now it's the revision application is review application is there. Review application, you have to draft the review application also for the same. So it's just like we are filing a review application in the family court judge, family judge court. And now what would the format would be? The format would be like, okay, in the court of honorable principal family judge, that is the jurisdiction Lucknow, Indore, or so on. Case number this, application number this, and the review application are filed under the section number 114 CPC. So please mention keep in mind that under 114 CPC, the review applications are being filed by the court. Now, Honorable Sir, it's most respectfully submitted. In the brief, we will mention about that are the chronology of the events, or that are the things that need to be reviewed. Then I have mentioned the three bullets, and that after that petitioner submits that wired order that please to and we will annex that order, that exhibit number A, the copy of the order that need to be reviewed. That this is the order or the decree that need to be reviewed by the court now. And being aggrieved and the dissatisfied by the judgment on the data, the petitioner has filed a petition in the following among us grounds, and the grounds are there. For example, the grounds can be stated in like as per your will. Grounds can be like that there is a no proper use of the law, there is no as such a claim to were asked, there is no there was a decree that was passed, a ex parte decree. So there can be certain grounds. After that, the prayer is there, that okay, the prayer is there, therefore humbly respectfully stated that the honorable court may graciously please to review the judgment, and that is being done, or grants any as such other relief that it may court may deem fit so, and the proper circumstances are there in the present case, can be granted. Applicant would sign with the data in place, and the verification clause is there. Verification clause is very important for the same. And in that verification clause, then it would be like, okay, all the paragraphs of the pleadings, all the facts he verifies on his knowledge, and received, and the information that is being received is true to the true to the person, or true to the deponent who is just filing the review application. What is the purpose and objectives of the review petition? Review petition, if you are aggrieved of the judgment, you are dissatisfied by the judgment, and you want the higher court just to review, just to analyze the judgment, then you will file review application similar to the revision application that we under the criminal drafting. Criminal drafting is solely different from the civil drafting, but yes, somehow the nature is same. But both have the other grounds, other things. Both are different things. Both jurisdiction is different. Both nature is different. But somehow they are doing the serving the same purpose. Purpose is all just same. Anamika. Yes. Anyone else have any query? Please put in the chat box. And that's all for the today's drafts. Particularly, go with the drafts in detail. Already shared with you all. Yes. So, please go to for with the drafts in detail. Yes. Anyone else have any question? Please ask. Drafting is all about just how many drafts you can prepare on the daily basis, how many practice it just make it practice makes the man perfect, and drafting is just like a crafting, just refining and getting enriched very day by day. It's not a one day thing that you just acquainted with the fact, okay, under section number 14 the review application is filed, so we have learned the section. No, it's not about that. It's about how you put in your facts, because pleadings depends upon litigation, depends upon the presentation of the pleading so far. No one else have any question? Everyone acquainted with what I taught today? Brilliant. Either gives a thumbs up. Now it's not a monologue session. Okay, then Vijay is there. He is the first one, and Anamika is also there. Sony is also there. Yes, they are regular students. Nagendra is also there. And Rahul is also there. Akash is there. Yes, these are the 7 to 8 regular students. Review petition is filed in the same court. No, as per the hierarchy, the review petition is filed in the higher court. How could you file the review petition in the same court which pronounced the decision before or after the some court? No, no, no. As per the hierarchy, you can file the review petition in the higher court. Simi. Some other court will review your order. No, that's why. Yes, anyone else have any question? I think no one have any question. Please go through the drafts. And today's task is to draft the WS for the our said yesterday's plate. So please forget not to fulfill that complete the task. Written statement for yesterday's plaint under the matrimonial dispute of section number 13B of Hindu Marriage Act 1955. Yes, Ranvijay. I think Ranvijay is there who is just listening to me very carefully and diligently. Anamika is also there, and Sony is also there. Can we amend or edit the WS after the submission if there happened a mistake? Sony, there are no such provisions, but sometimes the editing or the amendment in the pleadings lead to the disqualification. So, Sony, this is not a normal course to do. If the court allows to, then only. And there is no scope of mistake in the court. So, should we wrap the session? I think that's all for today. If the legal vidya is there, please wrap the session, or else, dear participants, thank you for joining. And please do revising the drafts. And we'll mention the task in the group also. Thank you.
Thank you, ma'am. Thank you so much for making this session so knowledgeable and amazing at the same time. Also, I would like to thank everyone for joining the session. Thank you, ma'am.
Thank you, Legal Vidya. Thank you, Kushbu. And good night, everyone. Stay healthy, stay safe, and happy learning. And please revise the drafts. Good night.
Now, everyone is requested to please leave the meeting. Thank you.